Okay, it's showtime, and today is a really super special episode. I know that we always say that they're special, but today is really special. Today with us, we have Jane Sims, Esquire, and today I'm going to talk to you about estate planning and real estate. And I think it's such a crucial thing for people to understand because really, you know, the way that you title property is indicative of how the property is going to be owned and controlled after death in many instances, but it's not really something people think about to the extent that who's going to get their home when they die, how our taxes are going to be handled, and that's why we're talking with Jane. I've known Jane for, can you believe it, this fall will be 30 years. We met in 1979 in first grade, and here we are 30 years later, both lawyers, and here we go. So why don't you tell us a little bit about, you know, what are some of the big misconceptions about estate planning and real estate?
Sure. Well, a lot of people think that, I have a will and all of my property is going to pass based on the terms of my will. One thing I like to emphasize to clients is that titles trump wills. And if you remember nothing else from this episode, remember those three words. Because I'll tell you a little story. I'll tell you a story about a client who bought a very large piece of property, worth about $4 million, and this significant portion of this client's net worth.
Bigger than my house.
And wanted very much to benefit his children with this property at his death, but titled it, jointly, tenants by the entirety with right of survivorship with his third wife. Not realizing that this meant that upon his death, that property, that significant portion of his estate, would pass directly to his third wife if she survived him, rather than to his children, even though his will read that everything should pass to his children. I hate to see people's estate plans get completely overturned by a mistake in titling. And that's why when you're buying a house, you are very concerned about which house to buy, am I getting the best price, how did the home inspection go, and titling can become an afterthought. But really, when you think about putting names on that title, you should be thinking about your estate plan. You should be thinking about what will happen to this property upon your death. Because this is the time to get it right when you put it on the title.
I was going to say, I really think that, closings, whether they be for purchases, even for refis, I think are kind of a good benchmarking time to go sit down and look at your will, to look at your assets and look at the deed, make sure everything is conveying the way that you want it to.
Right.
I think, that people often make the mistake with wills, and I'm sure you see this all the time, where they think, well, I did it, it's done, it's 10 years ago, I did it, it's fine. But needs change, desires change, interests change, and maybe you're not conveying the stuff that you wanted to convey the way that you wanted to convey it.
Right.
And I think also with certain situations with titling where you title things as tenants by the entireties where, mom dies and dad gets the property, you really can't, the son can't contest and say, well, I was expecting, because no, the title trumps the will, and basically you're not getting any stake of the property.
Right. And when you are purchasing a house, think about it as a major asset in your estate. A lot of people think, well, I don't know very much. I don't have very much money in the bank, so what do I need a will for? Well, this piece of real estate that you own, the equity in that real estate is an asset that should be passed, to your spouse or children upon your death. And if you have the property title just in your name, you want to make sure that you have a will that designates who gets the property at death. And, if you have it titled jointly with your spouse, in the event of the death of both of you, that property is going to pass by will. So you want to make sure, again, that you have a properly executed and valid will in order to pass that property. I also wanted to mention estate tax.
Yes, that is a huge issue that I don't think people really understand until they're left in a situation where they're paying lots of money for their ancestors' or assets.
Exactly. A lot of people think, well, didn't the estate tax go away? Isn't the limit exemption really high, so I don't have to worry about it? Well, that is the case for federal purposes. The estate tax has not gone away, and based on the way the economy is going these days, the federal estate tax probably will not go away. But right now, the exemption amount is $3.5 million. So every individual can pass $3.5 million upon death. Now, you know, that's a significant amount of money, and a lot of people are well under that limit. However, if you live in Maryland or in the District of Columbia, the amount you can pass free of tax is limited to $1 million, which is significantly lower than the federal threshold, and it catches many people in its net without them being aware that they ever had a taxable estate. And what constitutes $1 million? Clients still come to me and they say, "Well, I don't have $1 million in the bank, so this tax doesn't apply to me." Well, it's not just what you have in the bank. It's the equity in your house. It's the proceeds of your life insurance policy. It's your retirement accounts, your IRAs and your 401ks. So many people who don't consider themselves millionaires fall into the taxable regime in Maryland and in the District of Columbia.
And talk about what the actual taxes are. If you go over that threshold, how much are you writing Uncle Sam?
Well, the tax rate in Maryland is approximately 16%. It's the way the tax law is drafted. It's complicated. There, you know, it's somewhat graduated, and then it caps off at 16%. But it's important to realize that this could mean a tax of, you know, several $100,000s in Maryland when you have even if you have no federal estate tax due. And who doesn't want to save their kids a few $100,000s? And with proper planning, you know, for a married couple, with proper planning, you can make sure that both spouses utilize each of their exemptions, so that instead of $1 million getting to the kids, $2 million can get to the kids. But this doesn't happen automatically. You really need properly structured wills. You need to make sure that your assets are properly titled as well. Again, we're coming back to titling and how important that is in an estate plan.
And really, I think that people need to understand that not only can wills be updated and revised pretty much as often as you want, the same, to a lesser extent, is true with title, is that, you know, you want to make sure that the people that you want on title to own property with are actually the people that you want. And if there's going to be a transfer at your death, you want to make sure that you've titled the property so that it transfers the way that you want. And sometimes you see sticky situations where you own property with somebody that you don't really want to own it with anymore, and you can't just say, "Okay, I want you off title." You have to buy them out, or have, you know, somehow, you know, basically have them agree to come off of title. It's not just to go away, and they do.
Right. It's much easier to change your will than to get someone off of title who doesn't want to get off of title. People also think, "Well, I can do it myself. I can do my own will." Yeah.
Frankly, as a lawyer myself, I wouldn't even try to do my own will, because I think there's so many laws and there's so many regulations that if you're really not on top of your game, at the end of the day, you're just costing, you know, your family money when you leave them things, and you're leaving stuff on the table that you otherwise could protect.
Right, because those internet will packages, they don't address state estate tax laws.
You get what you pay for.
Yeah, and that can really be costly to the family in the end. Also, you know, when you do your own will, you might not be thinking about titles, and you might not be thinking about the beneficiary designations on your retirement account. And an estate plan is not just a will. It's a complete review and updating of all of your titles, all of your beneficiary designations, in addition to, you know, preparing other documents like durable powers of attorney for finances.
Medical powers of attorney.
As well as healthcare powers of attorney, living wills, which in Maryland are combined into a document called an advance directive.
And I think that people need to understand that, you know, you go to your doctor every year for an annual physical. I think you really need to do the same sort of thing, maybe not every year, but, you know, every couple years. I think you should do the same sort of sit down with an estate and trust attorney, because they can really make sure that your interests are protected, they're compliant with the laws, and that your assets and your, you know, things are going where you want them to ultimately go.
Right.
In the most cost-effective way. So with that, I'm going to sign off. Thank you all for watching. Please, as always, please, please, please forward this. Show this to as many people as you can, even people you don't like. Barrage them with this. It's important that they see it. To Brian, Jane's husband, I want to give a special shout. I'm going to give him 5. You know what? Forget. I'm going to give you 10. I think you need a 10. So I hope all is well, and thanks again for watching. Until next time, we'll see you.